Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan, and I am so excited to be back with you for this episode, talking about just a few of my favorite things. We've got Star Wars, Epic Games, Fortnite, union activity, statute reading. The list is full. But if any of that sounds interesting to you, please stick with us because we've got a great episode today. So starting out with, it's been an interesting week for the Star Wars character Darth Vader. As Fortnite, through Epic Games, announced just a few days ago, this will be a day long remembered. Speak with Darth Vader in Fortnite. Strategize with the ultimate Sith Lord with your voice, and he'll respond back using conversational AI. We're honored to feature the voice of the late James Earl Jones, and we thank his estate for the opportunity to make this happen for players. James Earl felt that the voice of Darth Vader was inseparable from the story of Star Wars, and he always wanted fans of all ages to continue to experience it. We hope that this collaboration with Fortnite will allow both longtime fans of Darth Vader and newer generations to share in the enjoyment of this iconic character, said the family of James Earl Jones, or the estate of James Earl Jones, that would have held the rights to his voice and likeness and other things about him after his death. But that's not the end of this story. Because, as with everything else in the world of generative AI, we've got misuse, overuse, illegal use to talk about. So, as this went out on Fortnite, we had stories like this one. AI voiced Darth Vader can swear, say, skibbity toilet, and I apologize if I pronounced that wrong, everybody, in Fortnite, how to find it. And yes, people were having Darth Vader do things like dropping the F-bomb, talking about skibbity toilet, and his thoughts on breasts, according to this particular article, as is the nature of the internet and getting computer and AI to do things that you want it to do. Of course, that's not what Epic would have wanted. That's not what the estate of James Earl Jones would have wanted. So immediately after these kinds of videos and these articles go up, Fortnite responds and says, we've pushed a hotfix immediately, and this shouldn't happen again. But that was just the start of the James Earl Jones Darth Vader discussion within Fortnite, because shortly thereafter, a link went up that said that SAG AFTRA, the union that represents voice actors as well as video actors, files a lawsuit over the Fortnite Darth Vader AI voice. Now, this particular image on your screen right now is at least a little bit inaccurate. There is no lawsuit here, but I'm not blaming IGN for that, because if we look at their actual article, it doesn't call this a lawsuit. We'll get to that in just a minute. Before we do, though, I want to point out that videos like this one on this channel are supported by people like you listening in podcast form, watching on YouTube, through Patreon, memberships, super chats, everywhere else where you can hit buttons and otherwise show your support for commentary like this. If you're interested in this topic, if you think I do a good job, please do consider supporting us at Patreon or elsewise. I really, really appreciate it. Now, as IGN said, voice actor union files unfair labor practice charge over Fortnite's AR Darth Vader, which gets collapsed on Twitter and social media into lawsuit. That's a fair kind of compromise, I think, for social media. I don't like it because I'm a lawyer and I'm very specific about the words that I use. But in order to communicate that there is a legal filing made, I think lawsuit is okay. And I do note here that Rebecca Valentine, the author of this article, does not make that same mistake. So the IGN social media team is doing some editorializing, even of the editorializing that is already present in this article and this headline. And sometimes those things happen. So it's an incorrect headline in that tweet that we just talked about, but it's an acceptable headline here where they say they filed an unfair labor practice. But what does that mean in practice? Let's take a look at the article. The Screen Actors Guild, American Federation of Television and Radio Artists, SAG AFTRA, is filing an unfair labor practice charge with the National Labor Relations Board against Epic Games after the company implemented an AI-voiced Darth Vader NPC in Fortnite last week. The complaint, which can be viewed here, and you better believe we're going to look at that in just a second, alleges that over the last 6 months, Llama Productions, owned by Epic Games, has failed to bargain in good faith with SAG AFTRA's video game actors and has made unilateral changes to terms and conditions of employment without providing notice to the union or the opportunity to bargain by utilizing AI-generated voices to replace bargaining unit work on Fortnite. Now, if you're hearing that and saying, well, who is even impacted? Who is the employee we're talking about? What do you mean you didn't bargain with the deceased James Earl Jones. Presumably you did negotiate a contract with the estate. The estate seems all on board with this use. So what are you talking about, SAG AFTRA? And that's immediately what I thought when I read this news article, when I saw this proliferating around the internet, because it's not immediately obvious what interest SAG AFTRA has in the estate of James Earl Jones licensing out his likeness and his voice to a party like Epic Games and Fortnite, except for the obvious, which is to say that generative AI and these kinds of licenses can put actors out of work, right? It is certainly the truth that new technology, including generative AI, can say, okay, we can do this with just voice snippets. We can do this with recordings. James Earl Jones obviously has a lot of them in Star Wars and outside of it. And so actors right now that are represented by SAG AFTRA can look at this and say, well, that's going to put us out of work. Maybe we should do something about it. It's an understandable position for the union. It's an understandable position for the actors. It's maybe not as understandable a position from a legal framework perspective. So hold on to that thought as we dive a little bit further in. However, continues IGN, the use of AI voices at all by Epic Games presents a major issue for SAG AFTRA, given its efforts to come to an agreement on a contract for its video game performers over the last year. The video game performing members of the union have been on strike for around 10 months now. The strike was started specifically due to a lack of agreement on AI provisions, even as 24 out of 25 other contract proposals had been affirmed by both sides. Yeah, there's a sticking point over AI. It's really no surprise that this lands most heavily on video games because video game companies are, at their base, tech companies and are more likely to adopt high-end, early-stage tech than maybe other aspects of the SAG AFTRA adjacent movie-making process. Earlier this year, SAG AFTRA publicly shared a breakdown of the portions of the contract still disagreed upon by both sides. We'll take a look at that in just a second as well, expressing that it was still frustratingly far apart on the provisions. In light of this, SAG AFTRA has issued a statement explaining its unfair labor practice charge against Epic. That might be a little bit strong. I'm not sure this actually explains everything. Essentially claiming that Epic's use of AI was undermining the work of human SAG AFTRA members who have previously or could potentially do work of matching Darth Vader's voice with their own performances. Here's the statement in full. We celebrate the right of our members and their estates to control the use of their digital replicas and welcome the use of new technologies to allow new generations to share in the enjoyment of those legacies and renowned roles. I'm not sure they're actually celebrating that with this action, but hey. However, we must protect our right to bargain terms and conditions around uses of voice that replace that work of our members, including those who previously did the work of matching Darth Vader's iconic rhythm and tone in video games. Fortnite's signatory company, Llama Productions, chose to replace the work of human performers with AI technology. Unfortunately, they did so without providing any notice of their intent to do this. And I've highlighted that particular statement because it's entirely unclear what legal obligation a company should have to the union to notify them that they're going to do something that essentially eliminates their need to use actors, right? If you were a video game company and you were planning on using SAG AFTRA actors to tape vocal performances of your role-playing game or any other game that you were making, and then you decide not to do that, you're just going to use text or even text-to-speech at this point in time because you think it works better for your game, do you owe a notice to SAG AFTRA that you're no longer going to use their actors? That's not usually how we think about labor or labor strikes or just labor unions in general. If you're not using that labor, you don't have to tell them you're not using it anymore. Your obligation is to bargain with them over the terms around which you do use the labor that is a part of their union. So it's understandable why they're upset about this. It's not as easily understandable why they would have a legal claim in this particular context. With the charge filed, the next step will be a review by the NLRB, the National Labor Relations Board, potentially followed by an investigation and hearing if the agency believes the charge has merit, or dismissal if the NLRB believes it does not. So yes, just like we saw with respect to the California statements against Epic, against Activision, apologies Epic, that one isn't on you. But just like we saw in that case, just like we saw with respect to Blake Lively and Justin Baldoni and the charging documents made with respect to California in that particular instance, this is a process by which a private party tells a government organization that they think there's something wrong. The government organization then evaluates that, decides whether or not it wants to pursue something independently, whether it wants to make a private right of action for the union or someone else to bring a case in that particular instance. It is not, as it stands right now, a lawsuit. But again, That's the social media team at IGN shortening things for headlines that can fit in the character limits of Twitter. I am at least somewhat sympathetic to that position, even if, as a lawyer who tries to be very precise with his wording, I don't really love it. In the event that it is determined Epic Games has committed an unfair labor practice, the NLRB can force it to remedy the situation in various ways. Totally true. Such as potentially hiring an actor to record a voice for Darth Vader, or removing him from the game entirely, or some other penalty. Yes, the first listings here of forcing them to hire an actor or remove him from the game entirely, those would be considered specific performance remedies under the law. Those are forcing somebody to do something or not do something, not use your Darth Vader generative AI. Those are less likely to be used by the NLRB than what is listed here as some other penalty, which is monetary damages, something along those lines. But again, I have certain questions as to whether or not this is even an unfair labor practice as presented here. And it's a very novel question. Generative AI is obviously very new. We haven't seen a charge like this made. So it's entirely impossible to, with 100% guarantee how the board might reply to a situation like this. I can only express for you in this video that I think it is perhaps a stretch, a reach of the use of the statute. And I will ask you the question as we end this video so that you can leave comments to it in terms of what you think should happen in a case like this one. But it's a very unusual circumstance, and I wanted to highlight it all for you because we haven't seen it in virtual legality before, and that always makes it interesting to me. So let's take a look at what they actually said happened here in their charging document, which you can clearly see is not a lawsuit. There's a lot more information in a lawsuit. We've read them for hours and hours and hours on this channel, and I'm sure you've seen them online. But this is a charging document against Llama Productions, a subsidiary of Epic Games, by SAG AFTRA, and it says the above named employer, Epic for this purpose, has violated the National Labor Relations Act by committing unfair labor practices within the meanings of Section 8A, subsection 1, and subsection 5. So we'll have to take a look at some statutes as well. Within the past 6 months, the employer, by its agents and representatives, failed and refused to bargain in good faith with the union by making unilateral changes to terms and conditions of employment, right? The National Labor Relations Act is only concerned with employment, but that raises another question, which is to say, is licensing out your vocal clips, even your visual likeness, is that a term and condition of employment for legal purposes? You're not employing anyone here. You're transferring intellectual property rights, likeness rights. So that already appears to be at least somewhat contentious of a point here. But we do understand that what SAG AFTRA is really getting at is that by using these licensed intellectual property bits, you are essentially eliminating the need to negotiate with these other people that we represent currently. And is that something that SAG AFTRA should have legal recourse to defend? But that's what they're saying here. I also want to point out that when they talk about what they're fighting over with respect to AI, they are very far apart. They've highlighted a number of contract provisions that they have issues with here. But one that they don't is that the current contract that they've agreed to that doesn't have any red lines or blue lines or anything else as part of their statements includes a term that says, in the event the principal performer is deceased at the time the employer seeks any required consent, the employer shall obtain the consent of the authorized representative who represents the deceased principal performer's exclusive rights as determined by applicable law. So when we talk about consent, one of the things they're fighting over is, what do you get when you get the vocal clips that you've otherwise bought when you sign an actor to perform motion capture or otherwise in your video game? Can you take those clips, everything that you've made that you're putting directly into your cutscenes, and generate new stuff in the future? That's the big fight that they're having right now. And they talk about this in respect of estates, and that's applicable to James Earl Jones in this particular case, and say, yes, you need to go get consent, but as long as you have that consent, you can use it for all the other reasons that we might otherwise negotiate. Now, it's important to note, this contract is not yet final. The reason that this is highlighted for you in the terms of a breakdown document as provided by SAG AFTRA is because the sides have not agreed on all of this. But I'm pointing it out here because this is language that is not otherwise seemingly controversial either on SAG's part or the employer's part. And so it is a common notion that if you go and get consent from a deceased party's estate, you're going to be able to use it for the reasons that an actor would otherwise be able to sign up for the same thing. And that makes total sense. That's what you would expect. You want, under the law, for people to have the authority to license out things like their vocal and identity performances. But then we get a little bit lower and we see where SAG AFTRA is really, really concerned. The parties acknowledge the importance of human performance in interactive programs and the potential impact on employment under this agreement when a generative AI system is used in lieu of performers to generate material for use in interactive programs that would otherwise be performed by those performers. Now, that's just a recital kind of paragraph. There's no argument here between the two sides. They're just including it so that we know where we are in the contract, because they're not sharing the whole contract with us in this document. But it's important because it's clear that SAG AFTRA is really concerned about this almost negative effect of generative AI, not really as concerned about making sure that the generative AI licenses are what they would want them to be, because that's not really an employee-employer relationship, but more on the effect that even entering into those licenses at all has on their ability to place performers that are currently in their union with these particular bodies. So it's a controversial, complicated position that SAG AFTRA has to take here. And then by the time you're getting into complaints that Llama and Epic have violated their National Labor Relations Act, you can see why they're doing it, even when it doesn't necessarily make a bunch of logical sense. So that's the contract breakdown. And it says at the bottom here that because generative AI is so new, the parties agree that the discussion in the future will include topics such as how to enforce anything that we're talking about here, because we don't even know what this looks like tomorrow, let alone next year. It's a very difficult negotiation for basically everybody in the creative pursuits to enter into right now. SAG AFTRA seems to be taking a more aggressive stance than other unions that have otherwise agreed to various parts of this. And certainly the video game portion of SAG AFTRA seems to be the most aggressive. Your minds can vary on whether or not that's a good or bad thing. I do think this is the kind of thing that the union should be interested in. I'm not sure that makes what Epic has done here a violation of the National Labor Relations Act. So in order to make that statement, let's take a look at what that act actually says, and in particular, the sections that SAG AFTRA says are being violated by Epic. So, it shall be an unfair labor practice for an employer to restrain employees in the exercise of the rights guaranteed in Section 157 of this title. That's subsection 1. They say this is being violated. And then in subsection 5, to refuse to bargain collectively with the representatives of the employer's employees, subject to the provisions of Section 159A of this title. So, SAG AFTRA says you're restraining employees in the exercise of their rights, and you are refusing to bargain collectively with the representatives of a union for this particular business model. And so we are assuming for purposes of this conversation that SAG AFTRA actually is a proper union to be forced to collectively bargain with on the part of Fortnite and Epic. I think that's a fair assumption. It would obviously be even worse for this particular story if SAG AFTRA has nothing to do with the actors that otherwise portray people in Fortnite, but we'll assume it for this purpose. And the real question is, can they say that just agreeing to a license of rights with the estate of James Earl Jones is interfering, restraining, or coercing employees in the exercise of their rights currently? And is it refusing to collectively bargain with those that are otherwise represented by SAG AFTRA? And I would offer a couple of points here. One, the unions always ignore this little piece of the collective bargaining section of the National Labor Relations Act, but this is important for this particular question. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through their representatives of their own choosing, and to engage in other concerted activities for the purposes of collective bargaining. They have the right to unionize or other mutual aid or protection, and this and is important, shall also have the right to refrain from any or all of such activities, except to the extent that such right may be affected by an agreement requiring membership in the labor organization as a condition of employment. Now, James Earl Jones, as a deceased person, is not presently being employed by Epic Games. What has happened is his estate has licensed out his likeness rights. So this isn't really a condition of employment kind of concept in this particular instance. And it's important to note that even if it were, if James Earl Jones himself were alive and decided to license out his likeness in this way, he has the right to refrain from joining in with the union activities. So SAG comes in and they say, you've refused to bargain with us over the terms of the AI license that you've entered into with a third party, here the estate of James Earl Jones. And so that's a violation of this section. But it looks to me like it's probably a closer question as to whether or not SAG is violating this section by essentially saying, well, any estate that wants to license out intellectual property that could otherwise put one of our actors out of work has to be deemed a member of our union, has to be working with us to collectively bargain the terms of that AI license, and cannot otherwise enter into an agreement on its own behalf, which cannot possibly be the case under this provision of the law. And so it does appear to me like SAG AFTRA is perhaps reaching a bit too far, even though they definitely have an interest in trying to maintain as many jobs for their members as possible. Continuing on, the other aspect that I wanted to highlight is that representatives designated or selected for the purpose of collective bargaining by the majority of the employees shall be the exclusive representatives of all the employees in such unit, and that any individual employee or a group of employees shall have the right at any time to present grievances to their employer and to have such grievances adjusted without the intervention of the bargaining representatives. Another way, given employees, even if represented by the union, can go and solve problems on their own, as long as the adjustment is not inconsistent with the terms of a collective bargaining contract or agreement. And as we've already talked about, the AI portion of the agreement is not yet settled. So it's entirely unclear what notice Epic or Llama should have to give SAG AFTRA when they enter into this contract. They haven't agreed to give any at this point in time. And so is this a violation of the National Labor Relations Act? I certainly have my doubts on that, even while acknowledging with sympathy that obviously a lot of people in a lot of jobs are going to be displaced by the work, by the abilities of generative AI in the very near future. And it is obviously very interested by the union that not happen to the people that are it's representing. So I understand all of that. And yet the law does not seem to cover what they are concerned with in this particular instance. That being said, that's Virtual Legality for today. Again, if you like this kind of analysis and commentary on video games, pop culture, business, and law, please consider supporting the channel on Patreon or through memberships and super chats when we do live streams, or otherwise just telling people that we're having these conversations. Every little bit helps, and I am so appreciative. Now, what do you think about this topic? Do you think James Earl Jones should have the ability to license out his rights or his estate to license out his rights to places like Epic? Should Epic have to go through SAG AFTRA to negotiate the terms of that AI license? Maybe you're just sympathetic to the actors in this particular circumstance. I certainly wouldn't blame you for that. And you think that SAG AFTRA is the best, most powerful place to actually force these companies to agree to reasonable terms. But maybe you think, hey, if my family member just died and they can help support their family even in absentia after the fact, they would want this to be done. And I want to enter into contracts like this, as they said in the original article, that he was the voice of Star Wars and he wanted to be a part of Star Wars now and into the future. And so you are recognizing and honoring the legacy of your family member in that particular instance. I can see both sides of this. As we say a lot here, reasonable minds can differ, but I'm very interested in your opinion. So please do let me know. And thank you for joining me on another Virtual Legality. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.